Hello, everyone. I didn't want to cancel this again. I've rescheduled a few times, so the notice isn't really out. Might just be me in here, but I wanted to take this chance to introduce you to my new story about the John Eastman disbarment hearing. This is Trump's election lawyer. I've been covering him for a while. He's an Orange County guy, local guy in California, although he did recently, in the last couple of years, move to New Mexico. He's still licensed to practice in California, and the state bar is trying to revoke his law license for his role in the 2020 election aftermath, the false election claims, and the which they say ultimately culminated in the January 6th riots. So he is has a hearing going on. It's basically like a bench trial before a state bar court judge in Los Angeles, Yvette Roland, and it's going to be back in tomorrow, starting at 10 a.m. We can watch online, which is pretty handy. But it was in session all last week, and I wanted to just take a chance to go over a news story I had on um, my let me see. What do I got here? Where is it? News story on legalaffairsandtrials.com about the attorney-client privilege issues that are coming up in the case. It involves Eastman's attorney-client privilege with Donald Trump, because Donald Trump was his candidate, or was his client, and so is the Trump campaign. And the Republican Party has actually waived attorney-client privilege. They did that during the January 6th committee hearings when that was going on, but Trump hasn't waived attorney-client privilege with Eastman. So Eastman is citing that when he's declining to answer some questions. And the questions where this has been coming up are the questions about fake electors, or not fake electors, but alternate electors. Some would call them fake electors because we have electors in each state that are used to certify the election. And there's part of the scheme to try to stop Joe Biden from becoming the winner, from it being certified for Joe Biden, was the thought that they could somehow replace the regular electors with alternate electors. And that's come up in various proceedings. And the state bar prosecutor was asking John Eastman about that when he was testifying. He actually took the stand as the first witness and was answering a bunch of questions about his actions in the election, or in the election aftermath, when he was working on Trump's behalf, and all the questions he was raising about election fraud. And of course, state bar prosecutors are trying to show that he had no legal basis for any of his claims, and that he actually knew that they were false and he was perpetuating them anyway. So my article kind of sums up a few days of testimony that I watched, and then online, and then in person. And it basically says that there are two divergent views on attorney-client privilege that have come up a couple of times in the hearing. And one is from Eastman, and the other is from Judge Rowland, who's a pretty important figure in this uh, hearing, because not only is she presiding over the hearing, but she is going to be the one to decide what happens. It's not like there's a jury there. Like I said, this is very similar to a bench trial. The standard is a little bit different than a civil case that would go, or a criminal case that would go before a judge, like in superior court. But it's the same standard, in that the judge is going to be the one who ultimately decides what Eastman's punishment could be. Prosecutors are recommending, they said this in their opening too, that they're recommending disbarment, but she could go lower than that. I mean, this could be a suspension, this could be a sanction. There are all ranges of punishment that she could impose if she does decide to impose anything. So obviously she's got a lot of sway here, and her view of attorney-client privilege, and in what she allows Eastman to not answer, is pretty crucial here. But Eastman was citing his privilege with Trump, or not his privilege, well, his privilege with Trump, but also Trump's the one who has the attorney-client privilege here, and it's not like Eastman can waive it on Trump's behalf. And there was kind of some talk in the pretrial hearing about, the idea that Trump is just going to show up in Los Angeles to waive it. That's probably not going to happen. He's pretty occupied with other things. But Eastman was citing this when refusing to identify people with whom he discussed the possibility of recruiting new electors. And state bar prosecutors say that this is an important point because it's part of the course of conduct that they're saying is part of their 11 charges against Eastman and basically the reason they're in court today. So they're they're trying to show a pattern of outlandish, outrageous, knowingly false behavior in the recruitment, and him talking about fake electors would be one thing. It actually first came up. Ronna McDaniel, who's the head of the GOP, testified before the January 6th committee about a call she had with Eastman and Trump, in which Eastman was talking about how he wanted the GOP to recruit alternative electors and thought that they should play a role in that. And the state bar prosecutor Duncan Carlin was asking Eastman about that, if he remembered the call or anything like that. There's Eastman right there. And Eastman was declining to answer, citing attorney-client privilege, saying that not only could some of the people that he talked about the alternate elector thing, he was arguing that Trump's attorney-client privilege might apply to those people, but then also that people who are his clients, he shouldn't have to identify them in that regard, because it would also identify discussions that he had with them. And that's Yvette Rowland there on the screen. And she was saying, when this first came up, that no, attorney-client privilege doesn't cover just who your client is. You would be compelled to answer that question. But Eastman's point was that the way the question was being asked, he would be revealing confidential communications if he confirmed who it was. So this came up, was it Tuesday afternoon, the first day of the hearing? They had opening statements, and then Eastman took the stand. This came up, it kind of festered, wasn't dealt with, and the judge said, okay, we'll deal with it tomorrow morning. This will be the first question tomorrow morning, and indicated she was going to go research this attorney-client privilege issue. But when we came back the next morning, she said that there were some briefs, a brief filed that she needed to look at with some case citations, and basically she had more research to do. So the issue did come up again when Eastman took the stand. He was only on the stand for a couple hours Wednesday morning, then it got interrupted by other testimony. But this attorney-client privilege issue just kept festering, and she revisited it on Wednesday, and then twice on Friday. And she said, but she just wouldn't deal with it. She just kept pushing it off and saying that it's a hypothetical situation. I mean, I could tell the attorneys were kind of frustrated with it, like when Rowland was saying, or when Miller was saying, we're happy to revisit it at any time, Your Honor. He appeared to be trying to underscore the need for her to do something about this, decide whether Eastman is right that in that situation he can't reveal the names of his clients because doing so would reveal the communication, or if he should be compelled to reveal the names of his clients. And then also the other issue of whether Trump's attorney-client privilege would apply to people who are working on his behalf or working on Trump's behalf. I think both of those are outstanding right now in Duncan Carlin's examination of Eastman. And Judge Rowland just said that she wanted to wait until that question or the situation comes up again in testimony to see if she needs to address it. And I mean, it just seemed to me like she was kind of pushing it off, not really dealing with this issue that she needed to be dealing with. And in one of the cases, she was going over some of the case law. So it was like she was trying to to deal with it. But she remarked that the case that was cited, she didn't think it was related to the current situation at all, because it involved a medical issue and HIPAA laws, and it just seemed like she wasn't really grasping what the attorneys were trying to say. But it was kind of frustrating for them, because I think, like I said, this is a pretty crucial issue in their in the state bar council's examination, and to really get through the examination of Eastman, they want to do that. So we might see it tomorrow when Eastman's back on the stand. But one thing that state bar prosecutors have tried to do is show that Eastman has waived his attorney-client privilege in interviews where he's talked about his otherwise confidential communications with Trump, and that's not just a one-time waiver, that once you waive that and talk about it with other people, you've waived it for good, and that should apply here. And of course, Eastman says that the waiver that he mentioned in this interview with the Harvard law professor and Matthew Seligman, who was actually Eastman's professor at University of Chicago Law School, they're saying that Eastman's saying it only applied to a few issues central to what he talked about. It doesn't apply to the larger issues he's being asked about in the state bar exam, such as the electors and who he talked to on that. So it's interesting that, almost a week later, that's still festering, because attorney-client privilege was obviously an issue in the email case before Judge Carter in Orange County that made such a splash last year. John Eastman trying to stop Chapman University from releasing his emails to the January 6th committee. And it instigated this review process that Judge Carter did, that, of course, attorney-client privilege was an issue there. It actually began with Chapman was saying that attorney-client privilege shouldn't apply at all, that Eastman had no expectation of privacy because he was using the Chapman email server, and he has to agree to that this is Chapman's property when he goes in there. But Judge Carter ruled that no, they were wrong on that attorney-client privilege should apply, because there are other attorneys who go through and he just said that it would have a chilling effect on attorney work at law schools and that kind of thing. So he said it did apply, but then he applied the crime fraud exception and made all those splashy rulings. And he was the one who actually first suggested to the January 6th committee attorneys that maybe he could apply the crime fraud exception to it, and issued these rulings ordering a few emails released under it, which I kind of brought that in to give some context and to actually and to draw some comparison between Judge Rowland and Judge Carter. Of course, one's a lifetime appointment federal judge, and she's basically an administrative law judge for hearings, state bar court, but just pretty different approaches. And I don't think the crime fraud exception, I'm not sure if that would even be applicable in state bar court, but it's not something that's been discussed or any kind of review that she's going on here. So she's looking at attorney-client privilege from a different standpoint when she considers the elector issue. But all that was kind of woven around Zoom testimony from prosecution witnesses. They called various election officials, and then also a highlight was Greg Jacob. He was called via Zoom Wednesday, interrupted Eastman's testimony and took Jacob's testimony. He's a partner at O'Melveny and Myers, lawyer in DC now, but he used to be Mike Pence's legal counsel, and he had the memorable exchange with John Eastman where he said, thanks to your bullshit, we are now under siege, when he was in the Capitol. So his testimony, I don't think, really revealed anything factually new for the January 6th crowd. It's always interesting to hear them in their own words and hear what they say. But I said, like I said in my articles at Legal Affairs and Trials.com, he basically brought to life that private exchange between him and Eastman about the thanks to your bullshit, we are now under siege. Because Eastman replied 11 minutes later, my bullshit, seriously, the siege is because you and your boss did not do what was necessary to allow this to be aired in a public way. You can see I've got the email here if you guys go online. You can check it all out. But Jacob addressed that in his testimony. Said it wasn't the what did he say? He called his language unbecoming of me. That was in a later email to Eastman, but he addressed it in his testimony too. He said he um, uh, sent it from the Senate floor, and that it was just not the kind of language and the due process he usually gives people when he sends emails. But his testimony's probably been a highlight. Greg Jacobs, and then also the state election officials. Just hearing from them in their own words. We heard from the Nevada Deputy Secretary of State for Elections, and he was talking about just the crazy rumors that they were hearing about Dominion, the voting systems. This is the company that secured the big defamation settlement against Fox News, and he was saying everything that they were owned by a Venezuelan dictator, to the fact that they had modems in their machines, to the Italian military satellites. And as he's saying this, he's like, I apologize, but I'm being genuinely serious. I mean, yeah, it just sounds completely outlandish, but um, and then in cross, Eastman's lawyer was asking him about a Nevada law that makes threatening election officials a felony, and it's a new law in light of everything that happened in the 2020 aftermath. And guy kind of snapped back at him. He's like, in the same that friends who had limbs blown off in Iraq now have free college for their kids. That's better, right? It was kind of a new factor, because there is actually aggravating circumstances that prosecutors are seeking against Eastman, involving the harassment that state election officials have endured. But that's supposed to be part of a separate proceeding, but we've still kind of heard about it here and there. They're going to do the aggravating factor after culpability. But one thing that became clear is we're not going to find out a resolution of this until at least August, probably not after that. I don't think she's just going to rule from the bench. But this was only supposed to be an 8-day hearing, but it doesn't start on time, and there are all these long breaks, unexplainable breaks, and the lunch always goes late. So now it's not coming back. It'll be back next week or this week, tomorrow, Tuesday through Friday, and then it'll take like a summer hiatus and come back August 22nd through the 25th. So it's kind of crazy that it's being extended so long, and it's like maybe she could start earlier. But there's a bunch of other cases, and everyone has their summer schedules, so they're not rushing this for sure. But pretty compelling testimony, I thought, from Jonathan Marks, Pennsylvania's Deputy Secretary for Elections and Commissions. He was talking about how the true triumphs of 2020, just being able to come together in an election during the pandemic, was overshadowed by the false fraud claims. But we also heard from Stephen Richer, who's a pretty well-known character, especially in Maricopa County, Arizona. He's a Republican who actually, right after he got done testifying, he announced he was suing Carrie Lake for defamation. She's the former GOP gubernatorial candidate in Arizona, who was trumpeting the false fraud claims, because Maricopa County includes Phoenix, and they were kind of the hotbed for that, because Arizona was one of the battleground states. And he was talking about how he actually talked about how that night he remembers election night, because he was actually losing his reelection too. But they most of these exams were just Carling and Samuel Beckerman, the state bar prosecutors, going through the various steps that the election officials took to secure their elections, and why they know that Eastman's claims are false. So they were asking Richer about a report by the Trump-friendly cyber ninjas, and he said it was done by a bunch of imbeciles who we later learned had no clue what they're doing, and probably fudged the numbers. So he was a colorful guy to hear testify, and it's just always interesting to hear them in their own words. But you can see there's the picture of all the reporters outside. But I just wanted to step in for a minute and update everybody. I'm going to try to keep watching it tomorrow. I am planning on covering a different sentencing in a case up in Los Angeles early in the morning, so I might miss a little bit at the beginning. But what I want to see is what's going to happen with this attorney-client privilege. If she's going to make a decision on that, but it's just going to depend on when Eastman testifies next, and I think they've got a lot of other witnesses via Zoom that they're lining up. So I'm going to keep covering all that. But yeah, thanks everybody for tuning in, and I've got some other stuff coming up here, some interesting stuff going on with